नमस्कार, प्रभासाक्षी न्यूज नेटवर्क पर आप सभी का स्वागत है। उच्चतम न्यायालय के न्यायाधीश उज्जवल भुइयां ने विकसित भारत के लक्ष्य को लेकर गंभीर प्रश्न उठाए हैं। उन्होंने कहा है कि यदि भारत को वर्ष 2047 तक एक विकसित राष्ट्र बनाना है तो इसके लिए समाज और शासन व्यवस्था में व्यापक सुधार आवश्यक हैं। खासतौर पर विचारों की स्वतंत्रता, असहमति का सम्मान और सामाजिक समानता इस दिशा में मूल आधार बनने चाहिए। हम आपको बता दें कि बेंगलुरु में आयोजित उच्चतम न्यायालय बार एसोसिएशन के पहले राष्ट्रीय सम्मेलन में बोलते हुए न्यायाधीश भुइयां ने स्पष्ट कहा कि किसी भी विकसित राष्ट्र का निर्माण केवल आर्थिक प्रगति से नहीं होता, बल्कि सामाजिक न्याय और लोकतांत्रिक मूल्यों की मजबूती से होता है। उन्होंने कहा कि बहस और असहमति को अपराध की श्रेणी में डालना एक स्वस्थ लोकतंत्र के लिए उचित नहीं है। समाज में विभिन्न विचारों को सम्मान मिलना चाहिए और आलोचना को सहन करने की क्षमता विकसित करनी होगी। उन्होंने गैर कानूनी गतिविधियां निवारण कानून यानी यूएपीए के तहत हो रही गिरफ्तारियों पर भी चिंता व्यक्त की। आंकड़ों का हवाला देते हुए उन्होंने बताया कि वर्ष 2019 से 2023 के बीच हजारों लोगों को इस कानून के तहत गिरफ्तार किया गया, लेकिन दोष सिद्ध होने की दर लगभग 5% ही रही। उन्होंने कहा कि इसका अर्थ यह है कि अधिकांश मामलों में या तो पर्याप्त साक्ष्य नहीं थे या फिर गिरफ्तारी जल्दबाजी में की गई। उन्होंने कहा कि यदि 95% मामलों में आरोपी बरी हो रहे हैं तो यह कानून के अधिक उपयोग या दुरुपयोग की ओर संकेत करता है। न्यायाधीश भुइयां ने यह भी कहा कि बिना आरोप पत्र दाखिल किए लंबे समय तक किसी व्यक्ति को जेल में रखना न्याय के मूल सिद्धांत के विपरीत है। उन्होंने जोर देकर कहा कि जमानत नियम है और जेल अपवाद का सिद्धांत कमजोर पड़ता जा रहा है, जिससे न्याय व्यवस्था पर अतिरिक्त बोझ बढ़ रहा है। उन्होंने कहा कि इससे अदालतों में लंबित मामलों की संख्या बढ़ती है और न्याय मिलने में देरी होती है। विकसित भारत की अवधारणा पर बोलते हुए उन्होंने कहा कि देश में संसाधनों का समान वितरण होना चाहिए और आर्थिक असमानता समाप्त होनी चाहिए। उन्होंने कहा कि यह लक्ष्य हमारे संविधान के नीति निर्देशक तत्वों में भी निर्धारित किया गया है। उन्होंने यह भी स्पष्ट किया कि न्यायपालिका को अपनी स्वतंत्र भूमिका बनाए रखनी चाहिए। वह ना तो स्थायी आलोचक बन सकती है और न ही किसी सरकारी अभियान की समर्थक। उन्होंने राजनीतिक घोषणाओं पर भी टिप्पणी करते हुए कहा कि विकसित भारत का लक्ष्य एक राजनीतिक संकल्प है। जैसे अतीत में गरीबी हटाओ जैसे नारे दिए गए, न्यायपालिका को ऐसे नारों से अलग रहकर अपने दीर्घकालिक लक्ष्यों पर ध्यान देना चाहिए। उन्होंने सुझाव दिया कि न्यायपालिका के लिए वर्ष 2050 एक उपयुक्त लक्ष्य हो सकता है, जब संविधान और उच्चतम न्यायालय अपने 100 वर्ष पूरे करेंगे। यह समय आत्ममंथन और भविष्य की दिशा तय करने के लिए महत्वपूर्ण होगा। न्यायाधीश भुइयां ने सहिष्णुता के महत्व पर भी जोर दिया और वर्ष 1986 के एक ऐतिहासिक निर्णय का उल्लेख किया, जिसमें कुछ बच्चों को राष्ट्रगान गाने से छूट दी गई थी। उन्होंने कहा कि ऐसे फैसले केवल साहसी न्यायाधीश ही दे सकते हैं और यह हमारी परंपरा तथा संविधान की मूल भावना को दर्शाते हैं। उन्होंने कहा कि समाज में सहिष्णुता केवल सिखाई ही नहीं जानी चाहिए, बल्कि उसका पालन भी होना चाहिए। उन्होंने जाति आधारित भेदभाव और दलितों पर होने वाले अत्याचारों को विकसित भारत के मार्ग में सबसे बड़ी बाधा बताया। उन्होंने कहा कि समाज में अभी भी गहरी असमानताएं मौजूद हैं, जिन्हें समाप्त किए बिना विकास अधूरा रहेगा। उन्होंने उदाहरण देते हुए कहा कि यदि कोई परिवार दलित महिला द्वारा बनाए गए भोजन को स्वीकार नहीं करता या दलितों के साथ अमानवीय व्यवहार किया जाता है, तो यह किसी भी विकसित समाज का संकेत नहीं हो सकता। अंत में उन्होंने कहा कि प्रत्येक व्यक्ति के सम्मान की रक्षा करना ही सच्चे विकास का आधार है। जब तक समाज में समानता, न्याय और सम्मान सुनिश्चित नहीं होगा, तब तक विकसित भारत का सपना अधूरा ही रहेगा। बहरहाल, आइए आपको सुनाते हैं जस्टिस भुइयां का वह भाषण जिसमें उन्होंने बहुत बड़ी बातें कही हैं।
By 7:30 in the evening, I could complete the hearing. Now I am tired, I am exhausted, I am hungry. I cannot dictate the judgment, so reserve. So this is happening in vast majority of the courts in India. Look at the situation in other jurisdiction. The kind of cases a High Court judge deals in India or takes up, the volume of cases, I think it will be less than that in many of these developed countries. In America, for example, it will be less than 200 cases per year. And they take, after a hearing, there also oral hearing is almost prohibited there. In India, we can't stop oral hearing, of course. We can ration the time limit for oral hearing, but we can't altogether abolish oral hearing. Now, before coming to the criminal cases, in revenue matters, I have personally seen myself both from that side as well as while sitting on the bench, there is a general tendency to play safe. Not to speak of junior level officers, even officers at the level of commissioners and chief commissioners, they tend to play safe. When there is doubtful legal merit, even when a matter is covered, even when there are 500, 600 days of delay, they would continue to file appeals before the tribunals, income tax appellate tribunals, and 260A appeals before the High Court. Thereafter, even SLPs before the Supreme Court, they do not want to take a decision themselves, lest the vigilance is after them. So they want a judicial decision, judicial imprimatur on their, see, the court has said we can't do this. This decision they could very well have taken themselves, but they don't do that. This has also burdened the tribunals and the courts to a great extent. Then we had this settlement schemes like Sabka Vishwas Legacy Dispute Resolution Scheme 2019, insofar as the legacy cases under the central excise and service taxes are concerned. Then in the income tax, we had the Vivad Se Vishwas scheme of 2020. Notwithstanding the laudable objective of the legislature, the officers, departmental officers are so ingrained in treating the SSCs as some kind of their adversaries that don't accept the settlement proposals. We have seen cases coming right up to the Supreme Court challenging the settlement decisions of the high courts and the tribunals. So this is how things have happened. Now, let us come to the criminal cases. We have noticed that there is reckless registration of criminal cases, FIRs, in recent times. The judiciary has not directed, judiciary has not registered cases. For trivial matters, such as public demonstrations and agitations, even by students, sometimes even putting up memes, social media posts, FIRs are registered, investigations go on, matters come up to the Supreme Court. Supreme Court has to constitute SITs, special investigation teams. This consumes sufficient judicial time. Prolonged incarceration. Of course, I must also admit that many within the judiciary also suffer from this more loyal than the king syndrome. As a result, people continue to languish in jails for months and months together. PMLA cases, for example. I had said in my, while releasing a book in Bombay, I had said that PMLA is a potent weapon to fight the menace of this cross-border, this money laundering. But like any weapon, if it is overexposed, overused, it will lose its potency. And this is what is happening. As on 31/3/2025, the total number of ECIRs under the PMLA recorded was 7,771. Number of arrests made was 1,031. Trial has been concluded in only 47 cases. How do you justify keeping them in jail when the maximum sentence is 7 years? Months and years together. Now, let us come to the more draconian law, this UAPA case, Unlawful Activities Prevention, this cases. This is as per the information furnished to the Lok Sabha by the Minister of State for Home Affairs. In 2019, 1948 arrests were made. 1,948 arrests were made. Only 34 were convicted, conviction rate being 1.74%. 2020, 1,321 were arrested and only 80 were convicted, conviction rate being 6%. 2021, 1,621 persons were arrested, only 62 were convicted, conviction rate being 3%. 2022, 2,636 persons were arrested and only 41 were convicted, rate of conviction being 1%, 1.56%. 2023, 2,941 persons were arrested under under UAPA, but that year shows only 118 convictions, rate of conviction being 4%. So if you look at this data of arrest and convictions under UAPA, it shows a consistently low rate of conviction, hovering around 4%. And what does it indicate? It may indicate overuse of this law. I won't use the misuse of this, the expression misuse. Overuse of this law and its impact on the criminal justice system. How much time it has taken? How much weight the courts had to take on this? This shows that the vast majority of persons were arrested but could not be convicted, indicating that many arrests may have been premature and unsupported by sufficient evidence. This contributes directly to case backlog and pendency, besides raising fundamental question of bail, with the general percentage of conviction being always around 5% and less, and chance of acquittal being 90% and more. Question is, why should an accused be confined to jail for years and years and years together? Even 5 years, 6 years without charges being framed, without charge sheet being filed. Can it go on like this? This can't be a model of Viksit Bharat. Certainly not. This can't be a model. So, my idea of a Viksit Bharat is, as I said, an economic model where there is equal distribution of wealth. There is this acute discrepancy or the gap in the wealth distribution should disappear, and this is what our directive principles also say. When we speak of Viksit Bharat, certainly there should be more space for debate and dissent. Dissent should not be criminalized. There should be more tolerance towards diverse views, as we are expressing different views today. Divergent views should be respected. There should be more tolerance towards diverse views and criticisms. Recently, I had gone and addressed the Telangana High Court Bar Association. There I referred to that famous case by O. Chinnappa Reddy, one of our legendary judges. This is Bijoy Emmanuel case. I will not go into details of the Bijoy Emmanuel case. I said only a judge having the courage of conviction of O. Chinnappa Reddy could have authored a judgment like Bijoy Emmanuel. There he said, our tradition tells us tolerance. Our constitution practices tolerance. Let us not dilute tolerance. Going back to my address in Hyderabad, where I addressed the judicial officers, I spoke about the deep social fault lines. Viksit Bharat cannot countenance such social fault lines. Parents cannot insist that the children will not have food prepared by a Dalit woman. That cannot be a Viksit Bharat model. We cannot have situations where Dalit men, scheduled caste men are made to stand on the corridors and people urinating on them. This can't be the model of development. The respect of the individual must be protected. Now, Guru Krishna Kumar had spoken about the budgetary allocations. I have the figures with me, there's no point pointing out. It has always been less than 0.5% insofar as India is concerned. With such meager budgetary allocation, where can we have, as was pointed out, the ceiling fan, falling on the table of the learned judge? Where how the judges will function. Judgment writing and official notings is not the same thing. A work of a judge is not 10 to 5. Work of a judge is 24/7. So also I believe the work of a lawyer. It is not only confined to the court hours. During the court hours, orders are passed. Where is the time for judgment? It requires an intellectual exercise. What about the other mundane clerical things like correcting judgments? It takes a lot of time. Compare this with Brazil. Brazil is a G20 country like India. Brazil is a member of BRICS. Constitutionally, Brazil allocates 3 to 4% of its budget for judiciary, compared to less than 0.5% in India. So these are the different world models that we have before us. I also agree with what Gauba had said about the certain judicial orders affecting the economy. It is true. And as I said, judiciary always has the resilience to make the course correction. Certainly, from those judgments, we have learned a lot of lessons, and I'm sure in the days and years to come, judiciary will do the necessary course correction. But as I said, the executive has also created this problem. Retrospective taxation is the biggest problem, I would say, that a potential investor faces in India. Who brought that retrospective taxation? The first, it was the government only. To that after that Vodafone judgment, who brought it? So therefore, it has been a case of collective pluses and minuses. Certainly, the roadmap that we have placed by the political executive, that we will be a developed country, it's a very laudable objective, and it is an achievable objective with people at the helm of affairs like Gauba and Ravi. I'm sure we will be able to progress on the trajectory, but judiciary must remain judiciary. Judiciary can neither be an eternal critic nor a cheerleader. Judiciary must do it. That is the role assigned to the judiciary by the Constitution, by the people. That role judiciary must perform.
अगर आप भी लेना चाहते हैं देश दुनिया की तमाम जानकारी तो आज ही सब्सक्राइब करें हमारे चैनल को। साथ ही नीचे दिए बेल आइकन को जरूर दबाएं ताकि हर अपडेट आप तक पहुंच सके।